Today we're going to talk about the NDA, the non-disclosure agreement, also known as the confidentiality agreement, also known as the proprietary information agreement, and the secrecy agreement, right? I used to call it the confidentiality agreement myself over the years, but I find most people refer to it as an NDA, non-disclosure agreement, so I adapted. No big deal. But that's what we're going to talk about here today, in addition to discussing, is it needed? And how effective is it? Coming soon. Stay tuned. Hey guys, I'm John Kokolakis, and I help small and micro businesses comply with the law and face their daily challenges so they can focus on growing their business. And today, one of the things that we do when we're trying to grow our business is protect our secret sauce, so to speak, our confidential information. And that is what we're talking about, the NDA, the non-disclosure agreement. So what's its purpose, right? Well, generally what it does, it puts an obligation on the receiving party. The disclosing party would be, let's say myself, my business, and I want to give my information over to someone else, tell them my big idea, but I want them to keep it confidential. So that's the one obligation. And usually people stop at that and think that that's all it is, but it's actually more than that. It puts two main obligations on the receiving party. One is with regard to keeping the information confidential, keeping that confidential information confidential, but also making sure that the receiving party doesn't utilize that information themselves. That part sometimes sneaks in there. You want to make sure that you're protecting both those obligations. You're creating both those obligations that the disclosing party is putting onto the receiving party, right? So when does a non-disclosure agreement make sense? When do we want to use one? A lot of times people think that you want to use it immediately when you want to, let's say you have a cool, great business idea, that billion-dollar idea, or you have an awesome invention and you go to the investor and you think, with your business plan in hand and an NDA, that they're going to turn around and sign that NDA before they start speaking to you. And then you're surprised when you realize they don't and that they won't. And you wonder why. Why? Are they going to try to steal my idea? Not so much. Really what it is they see, investors generally will see 10, 20, 30, 100, thousands of potential people selling their business or selling their big ideas, so to speak. And they can't just agree to everyone because there's overlapping of ideas. What if I sign an NDA with you and someone else comes to me with something very similar, right? Well, then if that's the case, you wonder, what do you do? How can I give them my idea without them stealing it? Well, really what you need to do is tell them, how are you going to change the world? Tell them what you plan, what your business will do. What does it do? You do not have to express how you will do it. So think of it in terms of dating. You go on the first date, you flirt a little bit, you tell them what you're going to do, you tell them the value that you bring to the table, right? If they're interested and they ask you out for a second date, well, at that second date when you're going to express how you would do it, that's when the NDA needs to make its appearance. See the difference? Okay. So always set yourself up to be able to say the what you will do and feel that that part is okay, but never reveal the how unless you have an NDA in place. Another situation where you would require an NDA, where it's applicable, is in a scenario where we're dealing again with a restaurant or a pizzeria, and in that situation, the seller is selling their business and we have a buyer who's interested in buying the business. And the buyer of the business says, okay, seller, let me see your financials. Let me see what's going on. Let me see your records. And you're like, okay. But first you have to sign an NDA, right? Think about it. It makes sense. I'm willing to have you see my financials, but I don't want the whole world to see my financials. And let's say this deal doesn't go through. I don't want you to then be giving out this information left and right. It's private information. So you want to have an NDA in place in that situation. Okay? Then what types of NDA do we have? Well, there's two main types of non-disclosure agreements. We have the unilateral agreement, which is also called the one-sided, and then you also have the mutual non-disclosure agreement. Generally, people will default over to the mutual non-disclosure agreement, and that's not always correct, right? And so the example I'll use frequently is, let's say I come to an investor or I come to someone interested in buying my idea or buying my business, and I come with this awesome product. And while we're discussing it, they're like, wouldn't it be good if we did this? And maybe we tweak it a little bit, and then we do this. And you're like, wow, that would be awesome, good. It's okay, cool, make that happen. So now you go, you make the tweaks on your product that you've created, and you think you're gonna go to market, and all of a sudden, you're slapped with someone saying, sorry, it's a court order saying, you're done, you're stayed, you cannot move forward. Like, what do you mean, why not? They're like, well, remember that mutual NDA that we did? Yeah, so, but you didn't disclose anything. Well, actually we did. When we were tweaking that with you and giving you these ideas that you went back, that was actually our proprietary information. That was our confidential information. And you are now not permitted to utilize that, and you're not permitted to reveal it to the world. Whoa, talk about a slap in the face and a surprise, right? So these are situations where you want to be very, very clear that you're using a one-sided non-disclosure agreement. And you want to be very clear to the receiving party that you are the only one disclosing information. They are not disclosing any information to you, and you don't want to know any of their confidential information. See how that keeps it nice, crisp, and clean? Okay? But of course, there are situations where you do need a mutual non-disclosure agreement. Now, let's talk about the terms of the agreement. The main terms is, A, we have the confidentiality aspect. So first we have to define what is it that's confidential. We don't want to be overly broad and we don't want to be too narrow, right? But we got to define what that confidential information is and what we're going to do with that information, what our obligations are in conjunction with that information. Right? And then we also want to put in there the recourse. What happens if the receiving party doesn't do what they're supposed to do? What if they actually do turn around and go throw it out into the world? Well, we need to have some sort of injunctive relief and language in there with regard to monetary damages, right? But the main term, going back to the beginning, I'm doing this in reverse order, is we're going to have the parties. Who's going to be the disclosing party and who's going to be the receiving party? In a unilateral, it's simple, but in a mutual, it would be me. I could be the disclosing party in certain aspects, and I can be the receiving party in other aspects, depending whether I'm receiving the information or disclosing the information, and vice versa with the other party. And then of course we also have to have that information that's excluded. For example, I can't say to you, well, I want to have all this information confidential, only to discover, well, that information was already in the public domain. I could have Googled and got that information. Don't expect me to keep that information confidential, right? Or what if it's information that I obtained not through you, but I obtained it through a third party? You shouldn't obligate me to protect that information as well. Or what if there's a court order and the court is ordering me to reveal this information? Well, that language has to be addressed. What I will say is when we do put language with regard to that, at the very least, the disclosing party needs to have language in there, so if the receiving party is forced to give it, let's say based on a court order, that at the very least they have to notify you prior to giving that information out. This is very important. You don't want to wake up in the morning surprised when you see some information on the front page news. At least you see it coming. Okay? So that's with regard to the types, and then we had the terms, and we discussed a little bit on the exclusion. But then the question is it effective, right? If I do have this non-disclosure agreement, does it work? Well, yes and no. Typical attorney answer is it depends, okay? So what do I mean by depends? Well, I do have an agreement in place, and let's assume it's a beautiful, perfect, solid agreement, but then the receiving party does it anyway. What happens? Well, I immediately have to go get my butt over into an attorney's office, hire the attorney, rush over to court, request injunctive relief, moving forward towards monetary damages to be determined. In other words, we're going to battle, and we're going to litigate this, and we're going to go to court, and that costs a lot of money. And so what if you don't have that money? Right? And so that becomes the problem. The problem is the receiving party may have known this. And so they got you into it. They say, sure, don't worry, we'll sign an NDA, only to do what they wanted to do anyway. And what could you really do? But then you're like, well, why have an NDA? Well, an NDA is important because A, it sets the tone of the relationship. It lets them know you're serious to do business. And it's better to have something that you can utilize as opposed to not having anything at all, because then you wouldn't have a leg to stand on. I had a client the other day, and I needed to do an NDA for them. It was a unilateral NDA, and I expressed that very same thing to them. I go, listen, we could do it. Good luck. What are you going to really be able to do in this situation if they do A, B, and C? But I'm not saying we shouldn't do it. We definitely should. I'll draft one up for you. We'll get it going. We'll work with it. But I need you to understand that there may be potential issues later on, but I do agree that we need to have that, if that makes sense. Right? You know what also should make sense is subscribing to our channel. Please, if you want to see more, it actually helps. Subscribe, hit the little notification bell, put some comments. It helps as far as building up the channel, and it allows, I guess, for the algorithms of YouTube, the little gods within, to turn around and push this forward so more people get to see my channel. Right? So if you like what you see, please subscribe. Again, notification bell. Thank you for watching. John Kokolakis, and I'm out.